Chapter 4. The conceptual argument for the judicial obligation to apply the law. My first two arguments for the judicial obligation to apply the law are source-based. Stare decisis and legislative supremacy find their legal source in the practice of common law judges. Stare decisis requires judges to apply the law found in cases. Legislative supremacy requires judges to apply the law found in statutes. An independent basis for the judicial obligation to apply the law also exists, which relates not to judicial practice, but instead to judicial function. Rather than focus on what judges do when deciding cases, this argument concentrates on the judicial role in common law systems. In other words, for a legal system to be a common law system, judges must fulfill this law-applying function, at least much of the time. In ordinary cases, judges apply a pre-existing legal rule precedential, statutory, or constitutional to the facts of a dispute and arrive at a resolution to which the parties are bound. Of course, lawyers and judges frequently disagree about precisely what result the rule requires, or even what rule should apply. But the important point for my purposes is that lawyers, judges, and litigants all agree that it is the judge's role to determine which rule applies, to apply that rule to the situation, and to resolve the legal dispute. My reference in the previous paragraph to the agreement of participants in the judicial process as evidence of the judicial function may lead a Dworkinian to wonder whether I have been semantically stung. I believe I remain unbitten, however, because I do not claim that the bald fact of agreement, standing alone, creates the judicial function that most participants in the judicial process would agree judges fulfill. Instead, I argue that part of the point of adjudication is the resolution of legal disputes, and that part of the point of common law adjudication requires judges to resolve disputes through particular methods of legal reasoning. These methods of reasoning require that judges consult authoritative legal sources, such as precedent, and resolve disputes in accordance with these sources, or, in their absence, in accordance with accepted methods of reasoning, e.g., analogical reasoning. Dworkin agrees. He recognizes that any minimally accurate account of common law adjudication must account for the authoritative force of precedent in judicial reasoning. Dworkin also accepts that judges must either follow precedent or justify their departure from it according to appropriate methods of legal reasoning. The agreement of participants in the judicial practice about the judicial function within that practice is persuasive evidence, though not necessarily conclusive proof of the judge's role. But if we accept that part of the point of common law adjudication is the resolution of legal disputes through principled judicial decision-making, supported by justificatory written opinions that are intended to serve as precedent for the future consideration of lawyers, judges, and citizens, then we can begin to evaluate the nature of the judicial role in common law systems without running afoul of Dworkin's semantic cautionary tale. Ordinarily, of course, there will be no legitimate justification for a judge to depart from the law as stated in an authoritative source. If we assume that a particular, unobjectionable legal rule governs a given dispute in a certain way, then a judge must arrive at a determinate result. Neil McCormick explains, if in any case one party to litigation establishes that the other party is legally liable to him in damages, then the judge must give judgment in favor of the successful litigant. What makes this so seemingly obvious is that it recites what is on the face of it, an almost tautological proposition about the judicial function. Behind it there lies what some people would consider basic presuppositions of legal thinking, that there are rules of law, and that a judge's job is to apply those rules when they are relevant and applicable. So what we are in effect presupposing or postulating is that on this view of the judicial function, or the judge's job, every judge has in virtue of his office a duty to apply each and every one of those rules which are rules of law whenever it is relevant and applicable to any case brought before him. Professor McCormick recognizes that the judicial function carries with it normative duties, which judges may or may not fulfill, that is, that judicial function and judicial obligation are interrelated. Judges do not simply happen to apply legal rules in certain ways. They must do so. McCormick rightly appreciates and emphasizes this connection between judicial role and judicial responsibility. That must is not the must of causal necessity or of logical necessity. It is the must of obligation. The judge has a duty to give that judgment. It is merely banal to observe that his having a duty so to give judgment does not mean or entail that he does, or that he will give, or that he has given such a judgment. All that strictly follows is that the judge would be acting in an unjustifiable way if he failed so to give judgment. The judge's issuing an order is an act which he performs or does not perform, and in so acting he either fulfills or does not fulfill his duty. In this passage, McCormick notes that the judicial function itself carries with it a legal obligation for judges to apply the law. If a judge disregards the law, she disregards her role and her responsibilities. Dworkin endorses this view. He expresses this point by maintaining that a particular plaintiff or defendant establishes a right to a favorable judicial decision through the mechanisms and process of litigation. Moreover, Dworkin accepts that in many cases, it will be obvious and uncontroversial that a litigant has a right to a judicial decision in his favor. So where the law is clear and the legally determined result is straightforward, Dworkin argues that one litigant has a right to prevail in court, and that the judge has a duty to resolve the dispute by validating and enforcing that right. Dworkin disagrees, however, with the account of legal sources that I presented earlier. Although he accepts that precedents, statutes, and constitutions are indispensable to any minimally accurate account of Anglo-American law and legal reasoning, he believes that these texts do not fully determine an individual's legal rights and duties. In other words, while Dworkin accepts the importance of legal sources for legal reasoning, he would not accept that the limited domain of materials relevant to legal reasoning and judicial decision-making is as limited as I have rendered it. For Dworkin, when judges attempt to determine what legal decision should be reached in a given case, they must take account of all relevant data of political decision-making. The texts of cases and statutes are a necessary, but not an exclusive, part of this process. According to Dworkin's account, when judges determine what the law is in a particular case, their determination is the product of a particular interpretive method and attitude that requires them to construct the law as they reason. And this construction rejudges and unjust laws, requires judges to consider not only textual materials, but also legal tradition, institutional practice, social history, cultural norms, political morality, and so on. Deep-seated as this disagreement may be, it is beyond the scope of this book. For my present purposes, I want to note Dworkin's belief that judges must identify what the law is. I also want to note that the judicial identification of the law must take account of, among other things, the limited domain of legal sources, as I have used that term, and that judges are typically obliged to apply the law as they find it in these textual sources. Although they may disagree about many things, Dworkin and McCormick agree that when judges decide cases, they must consult the textual materials. Moreover, they agree that judges fail to meet their legal duties if they neglect or refuse to consult these materials. Of course, judges will disagree about what the legal sources require in a given case, and they may sometimes disagree about which legal sources bear on a particular decision. I want to emphasize here the central importance of the sources for the common law method, and the constraints the sources place on the common law judicial obligation to apply the law. Deriving the judicial obligation to apply the law from the judicial function leads to two further points. First, the connection between judicial obligation and judicial function should always be understood in the context of a type of legal system. Common law judges are obligated to apply the law because that is an integral and irreducible aspect of their role within a common law system. Stated differently, part of what it means for someone to be a judge in a common law system is that she must ordinarily apply the law, and part of what it means for something to be a common law system is that its judges are required ordinarily to apply the law. Moreover, the common law requires its judges to provide the reasons for their decisions, and their reasoned decisions provide the basis for future judicial reasoning and rulings in other cases. The failure of common law judges on trial or appellate courts to explain adequately the reasons for their decisions often results in the invalidation of these defective decisions. Judicial functions differ in different types of legal system, and these differences reflexively relate both to judges and to the legal systems in which they function. Second, the fact that the nature of the judicial function gives rise to a judicial obligation to apply the law does not mean that this is the exclusive judicial obligation in the common law setting. Judges and lawyers frequently make this mistake, viewing the judicial obligation to apply the law as exhaustive of the judicial function. The United States provides a useful example, though this choice might seem curious at first glance. American judges are often considered to have the widest discretion and the broadest judicial authority in the legal world. American judges interpret statutory language and legislative intent and, most important, review legislation to ensure its consistency with the dictates of the U.S. Constitution. This is precisely why I have chosen the United States, with its tradition of an extraordinarily powerful judiciary, as my example. My concern here is unjust laws. As I have already explained, I am not interested in statutory interpretation as a tool that might assist judges in avoiding the patently unjust results countenanced by a particular statute. I also am not interested in courts invalidating unjust statutes as violative of a written constitution. I accept that a canonical document, such as the U.S. Constitution, will in many cases afford judges with a legitimate legal basis for invalidating unjust statutes. But not all unjust statutes are necessarily unconstitutional. Well-known examples from the United States are statutes permitting state-sanctioned racial discrimination that arguably did not violate the U.S. Constitution. The question that interests me is, what legal grounds are there, if any, for a judge to refuse to enforce a statute that is unmistakably clear, conceitedly constitutional, and manifestly unjust? Almost all American judges would respond that there is nothing they can do, as the U.S. Supreme Court stated in Chung Fook v. White. The words of the statute being clear, if it unjustly discriminates, or is cruel and inhuman in its results, as forcefully contended, the remedy lies with Congress and not with the courts. Their duty is simply to enforce the law as it is written, unless clearly unconstitutional. These are not the resigned remarks of a timid lower court. This is the statement of a notably powerful tribunal. This passage expresses the widespread view among American judges that once statutory interpretation and judicial review are eliminated, judicial authority recedes, and the judicial function reduces to unvarnished application of the law. Underlying this view is the deferential attitude, discussed earlier, of U.S. judges toward the legislature and its enactments. This judicial deference is the product of commonly held beliefs among judges and lawyers concerning the separation of powers in the United States. The powers allocated to judges, even augmented by statutory interpretation and judicial review, are bottomed on the obligation to apply the law as it is, no matter how unjust it may be. Complaints of injustice, however severe, must be directed to the legislature. Judges and unjust laws. The misstep in this thinking lies in the view that the judicial obligation to apply the law is the sole obligation derived from the judicial function. If a judge perceives her role and the scope of her delegated authority as exhausted by law application, she will naturally conclude that there is nothing more she can do when presented with a clear and constitutional statute that happens to be glaringly unjust. The courts of the United States have repeatedly and unreflectively maintained this outlook, as in the following quotation from a Supreme Court decision. We begin, of course, with the presumption that the challenged statute is valid. Its wisdom is not the concern of the courts. If a challenged action does not violate the Constitution, it must be sustained. Once the meaning of an enactment is discerned and its constitutionality determined, the judicial process comes to an end. This is not, in fact, the end of the judicial process. Where my argument is concerned, it is just the beginning. The common law judicial function does not generate only a judicial obligation to apply the law, and it should not be conceived so narrowly. The view that the role of judges in the absence of avenues for interpretation or judicial review is solely one of law application, unnecessarily restricts and inaccurately depicts their institutional position and authority. Of course, in most cases, where the law is fair and clear, judges must apply the law. But this does not mean that where a law is patently unjust yet constitutional, the judicial role requires judges to close their eyes, wring their hands, and apply a reprehensible law. A common law judge has an institutional and historical authority to articulate and defend, through reasoned opinions, her best understanding of the social values as expressed in legal principles that animate her polity. As I explain in the following chapters, these principles and values will frequently be expressed in constitutional form. But this form should not be mistaken for their nature. The textual and conceptual basis for judicial articulation and protection of fundamental common law principles and of common law constitutionalism inheres in the institutional role and responsibilities of the common law judiciary. Just as the judicial obligation to apply the law can be found in legal sources and in the judicial function, an equally fundamental obligation to develop the law can be found in Anglo-American legal sources and in the richness of the common law judge's systemic function. I begin my effort to establish this obligation in the next chapter.